If you're a business owner in England and Wales and you're in a dispute and you want to bring that dispute to an end, then you should watch this video. Alternative Dispute Resolution. It's frequently called ADR. When can you use ADR? Well, the question is at any point in time. If you find yourself in a dispute with someone, that dispute can settle on any given day. But what you need is two people who are prepared to settle, and ADR is a way, if nothing else, of getting people prepared to reach a settlement and reach a compromise. I mentioned that there are, to my mind, three types of ADR. The first was arbitration. Now, arbitration is often included in quite complex contracts, particularly contracts for building works. And there'll be a clause in a building works contract which will say if there is a dispute, then the parties agree to settle it by arbitration. Arbitration is a genuine alternative to court proceedings. It's kind of like private court proceedings. What the parties do is that they appoint an arbitrator and they agree before the appointment that they will be bound by the decision of the arbitrator. They'll then go into a process where each party will set out their case and they'll prepare it and present it to the arbitrator, and then that arbitrator will make a decision. And as I've said, both parties will have agreed to abide by that decision. And so that will be the end of the process. Now, there's obviously a problem with arbitration in that you've really got to trust your arbitrator, and how you agree an arbitrator can itself be a point of dispute. If you've got an arbitration clause in your contract, it's well worth using it. You're probably obliged to use it before you use court proceedings. If you're looking for a way to avoid lengthy and costly court proceedings, arbitration may be right for you because it might come to a resolution quicker and at more cost. But as I say, you are putting all of your faith in an arbitrator. Much more common is mediation, and mediation gets mentioned a lot in the news. What is mediation? In the context of the work that we do, which is commercial disputes and direct-to-shareholder disputes, a mediation is where parties agree that they will meet on a given day or over a number of days, and they will appoint a mediator. The process is usually that the parties will meet at an agreed location where there will be 3 rooms, one for each party and one for the mediator. At the beginning of the day, the parties usually meet to set out their positions, and after that the mediator will shuttle between the two parties trying to reach some kind of compromise, so that at the end of the day, both parties have a settlement. Mediations are very useful, though there's a couple of things that you should think about before entering into a mediation. The first is, are the questions that you want resolved clear to you? If, for example, you're trying to come to an agreed price for shares, do you have a valuation that you can trust? Does the other side have a valuation that they want to rely on? If you do, then great. You can come to some kind of negotiation based on the values within those valuations, and you can debate the methods of valuation and reach some kind of settlement. If you go looking for a sum for your shares, but you don't have any supporting evidence, you don't have a valuation, or the other side don't, then you're really just negotiating in the dark. That makes a resolution really quite difficult. It also means you may well come out with a bad deal. The other thing to remember about mediations is that they can be quite costly. You have to pay for a mediator, often for a full day, perhaps for longer. You would often pay for your representative to accompany you to a mediation as well. Now, usually mediation costs are split 50-50 between the parties, but our experience is that they can be around about £10,000 to £12,000 for a single mediation. That's because of those costs and because of the time necessary to prepare for it. So if you're going to go into a mediation, you've got to be clear about the dispute that you're trying to solve. Also, you have to be clear about your parameters. What looks like a good deal for you? What looks like a reasonable deal? What is your bottom line? And the fourth thing is, what happens if you can't reach a settlement at all? Are you going to go on with a court case, or are you going to walk into that mediation knowing that you have to settle on that day? I went to a mediation with somebody. It was an inheritance dispute, and we were in a very strong position, and we started negotiating from a position of strength. As we got through the day, my client took me aside and said, look, I have to come out with a settlement here. We can't walk away without having resolved this today. So we modified our position. We still got a good deal, but we modified our position because the client had to settle, in his mind, had to settle that day. At a mediation, if you are successful, then that's great. You're going to be put under pressure on the day at a mediation to come up with a signed agreement. Now, that's why you should have your legal representation with you. If you sign that mediation agreement, you will then be liable to an action against you to enforce it. So if you come to a mediation agreement, be careful, be absolutely sure before you sign it, because you will be bound by it. What happens if at the end of the day, at the end of a mediation day, there is no settlement? Well, that's happened to me a lot as well. Quite often parties simply aren't ready to make the kind of compromises required to come to a settlement, and so after long and frustrating days, people just walk away. If that happens, then usually mediations are part of court proceedings, or court proceedings are imminent or have already been issued, so that means the proceedings will simply continue. However, my experience is that mediations, even if you don't reach a settlement, can be very worthwhile because it becomes clear to you what the main concerns, the main agenda of the other party are, and similarly they're going to see that about you. So often people have mediations, they don't settle on the day, but maybe a month, maybe 2 months down the line, when the parties are clear of each other's positions, that's when a settlement happens. The third type of ADR we spoke about was simply negotiation. There's nothing to stop you in a dispute setting out your position to your best advantage, but then making a compromise. There's a convention in litigation which I can best label as being called without prejudice. Now, if you write without prejudice on a piece of correspondence, or you ring somebody up and say, this telephone conversation is going to be without prejudice, then that means that the content of the conversation or of the letter can't be put in front of a court unless both parties agree. Now, the purpose of this convention is to allow parties to make concessions with a view to reaching a settlement without being bound by those concessions until there's an agreement. So if you're in a dispute and you want to reach a quick settlement, there's absolutely nothing to stop you starting to negotiate right from the beginning using the Without Prejudice Convention. What I would say about negotiations is before you enter into negotiations, you really should be clear about a few things. The first thing is, what kind of position are you negotiating from? Do you have an idea of how strong your argument is if you took it to court? If you've got legal advice that you're in a very good position and that court proceedings have good prospects of success, then that may lead you to want to negotiate in a much stronger way. If you have legal advice that your position is not so strong, that actually you're in quite a weak position, then there's nothing to stop you negotiating and putting forward a very strong front. But you should know that your ultimate position is not that strong, and so you'd be more inclined to accept a lower offer than if your advice had been that your case was much stronger. The other thing that you should work out when negotiating, as with a mediation, is what looks like a good deal for you, what looks like an okay deal, and what is your bottom line. And finally, if there's no negotiation, or there's simply the negotiations are going nowhere, what is your alternative? Is it to just walk away? Or is it to issue court proceedings and carry those through to the end? If you're in a dispute at the moment and you'd like to know how to resolve it quickly using any of the forms of ADR we've just mentioned, then please get in touch. You can contact us by telephone or email, which are on the website, or you can go to our website and click the Book a Meeting button. That takes you through to my calendar and you can book a date and time to suit you to speak to me for free. It's absolutely free of charge, no obligation. I'd love to speak to you.